Yes, Lordship. The other day, the matter was taken up for some time, and thereafter, it was found that the main writ petition was not annexed. So today, I am carrying my writ petition with me. I think Lordship's record will also have it separately. Their whole case is that they have worked during the period that is from 10th of August 2017 onwards, and they were in-service candidates. And accordingly, they procured the D.EL.ED degree diploma 2 years. And they should be entitled for now the recruitment process. The Honorable Supreme Court in its order, finally that order which I have placed the other day, that there are two conditions that has to be fulfilled. That once that they should be in-service candidates from 10th August 2017 onwards. And also they should procure the degree by 31st March 2019. And for that, the Honorable Supreme Court says that after proper verifications, that order also I have placed. So now, if we look at their writ petition, they have in annex in page number 23 in the writ petition, Lordship. The writ petition number is 3794.
No. Writ petition 3794. Yeah. It was called for.
Normally, this is the practice that the writ petition is fully annexed. In the
that's true, but then there are many courts where it is not annexed. Like the court I come from, it is always placed along with the records of the writ petition. But
here also in Guwahati High Court also same is the procedure.
Yes.
If Lordship is pleased to come to page 23 of that writ petition, paragraph 2. The pleadings, paragraph 2, Lordship.
Yes.
Page 23. May I read 2 lines from that paragraph?
Yes.
The petitioners begs to state that they are working. That means presently they are working. We are working as teachers in private, government-aided and unaided schools in the state of Assam. The petitioners have experience of teaching in lower primary, upper primary school for last 9 to 15 years. The petitioners have completed 18 months D.EL.ED in elementary education through open and distance learning mode from NIOS, which qualification hereinafter to be referred as D.EL.ED ODL. So now this is their standard, they are working. Now Lordship will come to their applications which they have annexed. They were not hiding anything and they have annexed the applications for the service, page 55 onwards. All the applications which they have filled up online for applying for the job in the recruitment process. Lordship will see page 55, annexure 2. This gentleman name is there, Vikas Dev. Lordship will kindly see down below, Institute of Diploma in Elementary Education, 2 years course, South Karimganj AMC Model College. They have written that. Next page, Lordship will come page 56. In the middle, are you an ex-serviceman? No. Are you working as a teacher? No. All the applications I have gone through, Lordship. Everybody has very candidly and frankly and honestly, they have written that they are not working. So first they have to tell before this honorable court, are they working or they are not working? If it is a working candidate, Lordship, the situation will be different. If it is a non-working situation, and they have also said that they are working for last 9 to 15 years. But in the applications, they have very categorically said that I am not working. So there is a totally opposite, diametrically opposite stand they have taken. Each are in conflict with each other. And now why they have come? Because they are not being able to produce their appointment letters. their salary slips, all the vital things which are present for any employee. What we have asked, Lordship, we have asked the previous page, Lordship will find page 54. What we are asking them, appointment letter and accepted joining report of the applicant. That is first document we are asking. Minutes of the school management committee, that is mandatory for all private schools. They must have a managing committee, and some annexers also they have annexed. Then third, photocopy of the attendance register. Fourth is certificate issued by the school authority specifying the service of the applicant in the school from 10/8/2017. But what they have annexed? Experience certificate. All the certificates they are annexing or submitting to the department is their experience certificate. That we are not asking for. Then salary statements, and last is UDIs. And I have found a lot of the candidates have annexed certificates of experience where the school's UDIs code is there. It is not that it is not available. My humble submission is that they are not coming before this honorable court, before the learned single judge, as well as before this division bench with clean hands. They are hiding something, and that thing we are trying to find out through the verification process, which the Honorable Supreme Court in very categorical terms said that verify, and if they are found to be in service on 10th August 2017, and if they have procured their degree by 31st March 2019, but here the certificates also say that they are procuring it from May 2019 onwards till 2023, they are getting this diploma degree.
Yeah.
So this is the fundamental thing. Unless they clarify this, Lordship, all other issues are not to be taken by this Honorable Court at this stage. Because if they fail to satisfy this Honorable Court, whether they are working or not working, and with an honest reply, in my humble submission, this Honorable Court, which is a court of equity, will not look into their claims. That is my humble submission at this stage, at the stage of admission of the writ appeal.
All right.
If my lords would permit, I would need 10 minutes, my lords. I had appeared for all the petitioners before the learned single judge, and today I am for some of the pleaders. Whenever convenient, I would need 10 minutes if my lord would permit. And all the questions, my lord, the learned AG has put, I have a direct answer to that with supporting documents.
Please.
So if my lord, can I make my submission right now, if my lord would permit?
I think let me first ask Mr.
Very well.
Chaudhary.
Very well, my lord.
First ask
Very
Mr. Chaudhary, and then we'll give time to you.
Yes.
so grateful, my lord.
My lord, the first answer which I would like to give is that in the particular form, we have given answer no.
Yes.
That is a fact. Why? That also the AG must explain that he has not. What is situation is like this, my lord. While filling up the forms online as teachers, the option which is available in the screen is, my lord, whether applicant is working as a state pool teacher / contractual teacher, regular teacher. My lord, these are terms which are normally associated with government appointments. We are basically in unaided private schools. So therefore, my lord, even if we write, that is not accepted by the system. Therefore, my lord, the answer is no. Because these are filled up online. So whenever we try to, my lord, put the answer, then it says whether you are working as a state pool teacher / contractual teacher or regular teacher. So we are neither of them. So therefore, automatically the system says
Where do we get that statement that this is the only
statement is not there, my lord, but that is the practice, my lord.
no.
Statement, huh?
No.
Statement.
Because I have that statement, I will show during my turn. It is a part of my compilation. I will show it.
All right.
Okay. Now, my lord, now what is the Supreme Court's order? Please come to the compilation which I gave the other day, my lord. Please come to page number 87. Now, state is relying heavily on this. Page 87 of the compilation. Statement to us. Let him prove. Page 87, para 40, Roman 5. We clarify that such of the teachers who were in employment as on 10th of August 2017 and who completed 18-month D.EL.ED program through NIOS before 1st of April 2019 shall be considered as valid diploma for the purpose of applying in the other institutions and for promotional avenue. Well, this paragraph does not say anybody's entitlement. It only says these are the people who are eligible to apply. Now, my lord, next para at page 88. We direct the respondent authorities to consider the candidature of such of the appellants who were in service as on 10/8/17 and that who on verification are found to satisfy the eligibility criteria. The verification which is mentioned, referred to here, is the verification meaning that before 1st of April 2019, he must have obtained the 18 months D.EL.ED course, which has been construed to be equivalent to 2-year diploma. And secondly, he must be on service on 10/8/2017. So, my lord, the learned single judge as well as the state's understanding is, by virtue of this order, this expression used that eligibility criteria, now they can come up with these new requirements. That is actually, my lord, in an appropriate case, the prescription may not be unreasonable. But as I have submitted earlier, but in the facts of the present case, it has to be construed as onerous. Because some of the documents, it is beyond our capacity, my lord, beyond our control to obtain it. Because some of the schools have closed. Now, regarding, my lord, the UDI's code, I'll just read one paragraph
Just a
from my
minute.
writ appeal.
Now, let us see, just show me the advertisement.
Yes. Advertisement in the compilation, lordships will get
54.
50, my lord. One is at 50, other is at 54. Now, please come to the conditions of recruitment. The Director of Elementary Education, Assam, reserves the right to cancel or postpone recruitment at any time. Is not important. The candidate who have passed ATET, CTET for lower primary will be eligible. Either the language 1 or language 2 or both ATET and CTET candidate shall match the medium of instruction of the school wherein the candidate wishes to apply. Then candidates should not be less than 18 years of age and not more than 40 years. Now, regarding children, all these are not very important. Then, yes. Now, please come to me, Lord, page 51. Eligibility criteria for LP school as per government in the department of so-and-so. So, higher secondary or senior secondary, so 5 marks weightage will be given. For diploma, so-and-so weightage will be given. For TET and central TET, so-and-so weightage will be given. Then non-essential, so this is not relevant. So these are the Millard qualifying requirements. The problem arose because, Millard, there was a prescription in the RTE Act that you must possess all the qualification prescribed by NCET. So therefore, since, Millard, there was a situation when within that 5-year tenure, some of the teachers were not in a position to complete 2 years diploma. It is in that context, Millard, that a via media was worked out, and that is how, Millard, Supreme Court also in the review order has eventually said that whosoever has acquired the diploma before 1st of April 2019 and one who was in service on 10th of August 2017, they would be eligible to apply. Now, we are only seeking to apply, take part in the selection process.
No, that's all right. But Mr. Chaudhary, tell us one thing.
Yes, my lord.
Now, you are required to be in service on 10th of August 2017.
Yes,
And then with 18 months diploma,
yes.
before 1st of April 2019.
We have both
You have
this.
to, you have to have this.
Yes.
Now, they are only asked,
How to verify that I was working on 10/8/2017. Diploma certificate we have, there is no dispute below. Because the particular school where I work, they have certified it.
the question is this.
Hmm.
Now, if it is a operate by day, fly by night kind of a school,
Fly by night operator.
fly by night operator, then perhaps the whole purpose would be defeated.
Then Milord, I could not have enrolled myself in that
You
diploma.
could have,
I could not have.
during the period,
I could not have enrolled myself.
no, you would not have continued for diploma unless that
Yes,
school was in
because
existence.
there was a provision of monitoring also. Please come to page 1 of this compilation, Milord. Page 1 and the
But
relevant.
what is this that you cannot furnish? What is there which you cannot furnish?
Yes, please come to page 76. Na? 96, Milord. B, C, E, and F. Milord, B, C, E, and F. And even if Lordship gives us some time, we cannot give F. F, they will have to find out. If Lordship gives us some time, perhaps we can try for B, C, and E. But F, we cannot.
If this, just a minute, this is just a question to you.
Yes, Milord.
If you have been recommended, if you have been forwarded by a school which is not captured under UDISE,
Yes.
then perhaps your endorsement is incorrect.
No, those data are available at NIOS. Now the inquiry committee, 4-member committee, which was constituted by the state, that did not include the representative from NIOS. Then things would have been clear. Well, unfortunately, before the learned single judge, though NIOS was made a party, but at our prayer, my lord, that it was deleted. That's why this time, my lord, seeking leave of your lordship, you have made them a party. Because they can answer whether we had the UDISE thing or not. And in paragraph 2 of the writ appeal, we have explained the position.
No, NIOS would not be the correct authority to know. UDISE is maintained by the state.
No, my lord. Actually, we had that number. If we have explained that position, if your lordship permits me to read paragraph 2 of the writ appeal, we have explained that position.
What have you said?
Yes. Page 18, my lord. Page 17. Page 18, sorry.
Repeat.
Yes, page 18. This is the first subpara. It is pertinent to mention that at the relevant point of time, certain schools, particularly in cases of appellants about 68, did not possess permanent UDISE codes. In such instances, specific one-time UDISE code were generated by the concerned Block Elementary Education Officer, Government of Assam, under the direction of NIOS, after conducting necessary verification of the service records and field inquiry. These one-time UDISE code were thereafter used for registering the appellants in D.EL.ED course. However, for reasons best known to the respondent authorities, those particular UDISE codes have since been deactivated, rendering the corresponding data inaccessible to the appellant.
Mr. AG, what do you have to say about this
No,
temporary UDISE?
Lordship, it is not the role of the appellants to get the UDISE. The school will give the address. Lordship will kindly come to page 68 of the writ petition. Page 68.
Yeah.
The certificate given by them. The school authority mentioned the school UDISE number 18180.
One second.
Lordship.
Yes. 68.
Page 68.
Hmm.
So the certificate issued by the school authority in regarding experience, they have mentioned the UDIs. And I have found about 10-15 certificates in this bunch of papers which have UDIs code. And another thing, Lordship, which my learned senior friend was saying, that two conditions has to be fulfilled. One is that they should be working on 10th August 2017 and they should procure the degree by 31st of March 2019. All the certificates, if Lordship is pleased to come to a certificate at page 55-56.
Yes.
All these certificates, Lordship, there's a date mentioned in the certificates. All these are beyond 31st March. Some certificates are showing 22nd of May 2019 and some even 2023. These certificates. I'll show the certificate, Lordship. Just 1 second. Page 60. Page 60 is a certificate of this Deb, Mr. Deb, because Deb. Page 60 down below, date is 22nd May 2019. So that is beyond 31st March 2019. Identically, every certificate, it is beyond this date. They do not fulfill this criteria also. If Lordship is come, please to come to page 86. Jailul Hussein's certificate. Down below, 21/7/2023. So how will they justify this now? This is their submission 5 minutes ago. That they have to procure the degree by 31st March 2019. Now this certificate is 21/7/2023. So everyone has a different case. The facts relating to an individual is separate from the others. Some has UDIs code, some has not fulfilled the criteria of this deadline, the timeline to complete the diploma course. So they can have all justifications, but their record is speaking totally different. We do not need justification. We need proper pleadings, categorical statements. When they are saying that I am not working, I am not working. But in paragraph 2, they are saying that they are presently working. They are now we are working as teachers of private, government-aided and unaided schools. That means they are working. On the other hand, they are said not working. They should have written that we are working in private schools.
No,
That
that's one aspect of the matter, Mr. AG. Now tell me, this 18 months diploma was a one-time
relaxation,
So
one-time waiving.
So this certificate would definitely be for 2 years.
I'm
17, 19.
17 to 19. This is for 2 years. But this cannot justify that to that extent you're right. This cannot be a test for finding out that they were in employment on 2010.
His Lordship, if they are having 2 years degree and if they are not in employment, that is not a disqualification. They are qualified. Those who procured 18 months diploma, they only have to be in service candidates. A rest can be a normal candidate. He may not be working.
Okay. So therefore, this certificate can be accepted.
He have enrolled in 2017.
So therefore, a person giving a certificate at page 86,
Yes.
he is entitled to appear.
I am not sure on which date he have entered the course.
No,
Whether
this is a 2-year course.
Then he qualifies.
That is what I'm saying. So
Then he qualifies. His case is totally different. He did not come to this batch of writ appellants or writ petitions. Normally he is qualified to participate in the recruitment process. He is eligible, Lordship, if that is the case. So everyone have a different story to tell before this court. They have different grievances. So this is not a common subject matter or grievance.
No, therefore, this learned single judge, instead of laboring so hard, should have said that no, all these petitions can't be clubbed together.
I'm not getting, Lordship.
No, if this were so, and this is exactly the position, the learned
Yes.
single judge should not have heard it in one go.
Yes, Lordship.
He
That
should
is
have
what.
raised that objection. He should have.
Yes.
I mean, this is. I mean, everybody has a different course. I mean, they can't club their petitions together. But
So-
this ground now cannot be taken because the decision has come.
The decision is come, but the fact it is a continuation of the writ proceedings. It's a continuation. Now they are impleading another party, NIOS, which was I have heard. They cannot do without leave of the court. Lordship may remand it back to the learned single judge also. I am open to that. But Lordship will not hear with all this different factual background of each individual appellant together in a single writ appeal. And that is why the learned single judge imposed a cost of 10,000 rupees for attempting to mislead the honorable court. They are themselves are conflicting with their stand. Every stage, they have a different story of explanation. Lordship may admit the appeal and fix it for hearing without any interim order.
UDISC.
Yes.
UDISC records are maintained where?
It is maintained by SSA here. Central government has empowered this Sarva Shiksha Abhiyan Mission Assam. There's a separate department.
But was there any situation sometimes in the past that there was a temporary UDISC code?
Lordship, I have a direct reply to that. If that be the case, the number will not get erased. Today, suppose I have done my 18 months D.EL.ED course in 2017 to 2019. That school is closed in 2021 according to them. In COVID, some schools were closed down, but they have recent certificates, every appellant. So suppose that will not erase my history. The school's old, I am not asking today's UDIS number. I am asking the UDIS number of that period. I have my matric admit card, roll number is there. My school is closed. My roll number will not get erased.
All right. All right. All right. Yes.
Yes.
Okay.
It pays to go.
It pays for 1,417 additional.
This cannot be decided today.
Because I need
On top of that, I am not taking Lordship's time. I know Lord, there's a
Mr.
time
Kalra.
constraint today.
Mr.
Lordship, just one
Kalra,
second.
but today we have a reference
I understand.
for which the court has to be, I mean, arrangements have to be made in court number 1.
We understand, Lord.
So I think it will have to go on another date.
Look, there's one apprehension, a problem that I would be very, I would want to submit before my Lord, my Lord. There is absolutely no problem if it goes to another day, my Lord. But there's some interim order that was there, operated before the learned single judge, my Lord. So the point really is this, my Lord. Now the stage is where there is a second provisional list which has come out. Now, if all the appointment letters are issued, my Lord, this will become an academic matter altogether. And more importantly, my Lord, after the passing of learned single judge's order, I'm saying this with responsibility, I produced it on record. The Honorable Supreme Court was seized of exactly the same matter. And I argued that with responsibility, I'm saying, after the learned single judge's order. And on the basis of what should be the document which has to be seen as an in-service document, the Honorable Supreme Court has given a finding. So therefore, my Lord, we will be able to substantiate that because the Honorable Supreme Court, after the single judge's order, has relied upon one document to say that yes, undisputedly they are in service. This is the line from the Honorable Supreme Court's order for the state of Telangana, for the state of Orissa, because this is an all India issue. Every state except state of Assam has followed the same procedure. Every state. So therefore, my Lord, I will not come in the way for some other day, but some interim protection needs to be granted, my Lord, because this matter cannot be academic, cannot be left to be academic in nature, specifically when throughout I have enjoyed an interim order before the learned single judge.
Again,
And all that I'm
incorrect,
saying is, just one second.
incorrect
Just one
statement.
second. Please let me complete. I didn't interrupt when you were speaking. And I'll be very fair to the court, my lord. I am not even saying whenever my lords want to have the matter, let the appointment letters not be issued to anyone. That is my only request, and I don't think Evans will.
That we are absolutely jittery at this prayer. We can't stall the process.
Then very well. Then, my lord,
Absolutely
please.
jittery.
At least 98 posts may be kept reserved, my lord.
And there are some
There are
applicants also that have come
5,500
in, my lord.
Don't
They are
worry,
some-
they cannot fill up 5,500 posts.
Because they are doing it. They are
No,
doing
they,
it.
they
my lord.
can't.
No,
they
at
can't
least
fill up.
100 posts they should not fill
My
up.
lords may not underestimate the government. So, my lord, and I will satisfy, my lord, whatever
100
questions
posts may
have
be
come in,
filled
we
up.
have direct
10 minutes
answers
filled
for that. Any
Mr.
third-
AG, what is your response to this prayer that 100 posts should be kept reserved,
So there is more than that. There are
I-
some applicants also.
subject to the outcome of this writ petition,
Yes.
this
Lordship,
appeal?
my
Appeal.
submission is very clear. Prima facie, they have not been able to justify their claim. Prima facie, from their own records. It is not that we are producing records. They are not being able to justify their own claim. Prima facie, no case is made out for any interim order. That is number one. Number two, Lordship, we are going ahead with the recruitment process. There was an interim order that was also vacated at one point of time. It was not all along the interim order was pursuing. Number three, Lordship, if it is a case of 100, all subsequent vacancies have arisen during this time. This recruitment process started in 2023, December. We have lot of other vacancies. Number three. Number four, whoever is appointed out of that 5,500, Lordship, we can write a line that will be subject to final outcome of this writ appeal. So, but still I am objecting to giving a blanket protection to them against 100 posts.
Then can
Let
I
us
request
fill up.
for one? Can I request for one thing? Can my lords have it on Monday for consideration of the interim protection?
Just a minute. This time you have advertised for how many posts?
Lordship, this is an old advertisement of
Old advertisement is for how many posts?
5,500.
5,500.
And how many have you issued notification?
Appointment order has not been issued. We are at the final stage on 9th. On 9th or 10th, we are going to complete the recruitment process.
And thereafter the notification.
Thereafter the notification. Lordship may take up this on Monday 10th.
Well, my lord, may take it up on this Monday, my lord.
And
regarding their additional pleadings now, that regarding NIOS, all these things.
All right, no. We will hear you on, we will hear all of you on 10th of November.
Lordship.
My lord, can I just take 30 seconds if my lord would permit? My lord, if the process is completed by then, my lord, then what will remain? If my lord may...
Doesn't matter. Before notification, we'll say it will be subject. We will decide it on that date.
My lord,
Today, we would have done it today, but for the fact that there is 10th. And this, if you're asking for next Monday, this quote is not available. This
500 posts, 100 posts will not make much of a difference, Millard. Only 100, Millard.
On
Till
10th, Lordship
that
will
day.
hear the matter.
no, my lord,
Monday.
Coming Monday.
No, coming Monday, this bench is not available. If you want, we can send it to another bench.
Oh. No, Lordship.
We will send it to
my
another
lord, can
bench.
it be any day prior to 10th? The problem...
No, that's what I'm saying, Millard. Let them finalize everything. Let them not give the final appointment order.
It shall not come. It shall not come on 10th. They are concluding it by 10th.
No, my lord, they'll be issuing appointment letters on before 10th. That is what they are saying.
They will not issue appointment order. At least no
Yes,
third party
let them
right
say
will be
that.
created.
Lordship, may I just interfere? There is a concerted move against this government to stall this
No,
recruitment
I'm
process.
sorry, my lord, I oppose such kind of submissions. I'm sorry, my lord. I will be able to
You may be
satisfy...
sorry, that is not my issue. I have to...
And my lord,
I'm addressing the court.
every state in the country is following one norm. Only state of Assam is having 10 more documents to bring in. On what basis?
Millard, this prescription is only prescribed in Assam, in no other states in
I
India.
have put the...
Assam
Lord,
is,
this is
Assam
again,
is,
this is
Assam
again
has its,
in.
just
No,
no,
just a
I
minute,
have-
let me
counter this.
I
In
will,
West
I
Bengal,
produce the
all
notice.
these
hold on for a
documents are
minute.
required.
Manoj,
Just
but
hold on.
every state
There
has
is a
its own
just hold on,
notification on
please.
record.
large level of fraud.
Please, let me respond to this.
Lordship.
Let me respond to this, not the parties. Now, every state is peculiar in its settings. So therefore, that cannot be a.
Malord, I have an answer to that. I have an answer to that. Malord, it is a central government course. Every state followed the procedure laid down by the central government.
All right, we will give you a detailed hearing. Fix it as first matter.
Because
Malord, but prior to
25
10th,
list
Malord,
3,
we
my
missed the
lord,
bus.
this state is supposed to follow the central prescription.
Let's see. We will.
Malord, the interim protection, Malord, with all due respect, Malord, will become infructuous if there's no interim protection.
I'm not.
Any day prior to 10th, if my lords would consider any day, especially at 2 o'clock if possible, Malord. Any day.
We can keep it on 11th. We can keep it on 11th as the first case.
Yes.
Malord, can I just make one last request?
some interim protection.
Interim protection means everything. Then everything goes.
Malord,
So,
can I make
my lord.
one
It
last
will be-
request?
It will be taken up on 11.
yes.
My lord, this matter was delayed because the other day they have taken time.
No,
The
it was
matter
not
was
that. Why
the other
taken
day.
time? The read petition was not there. Again, incorrect submission. Read petition was not annexed with the appeal. That is why the matter was taken up again.
Malord, we
But
are,
that point the other side has already pointed out. Read petition is still not there.
If we would highly appreciate, and we would be in a better position to adjudicate if this courtroom is not converted into a battleground. This is our, the entire energy is focused towards, the stop
No,
to
Lord,
people.
the only thing is, as a lawyer representing this
That's right.
candidates, my lord,
That's
I'm
right.
making that prayer. Otherwise, my lord, tomorrow.
We are giving this priority only for the reason that we are, as you would have seen, interim protection I do only when it is urgent.
Or at
and we are
least an
satisfied.
observation, any appointment made will be subject to the outcome of the writ appeal.
That he
that
says
is-
that he will.
Malord, that kindly record that, Malord. Kindly
Yes,
record
kindly
that.
record that, my lord.
Mr. AG, you agree for that?
No problem at all, Lordship. In fact, that was what I was saying also.
That all
All right.
appointment letters will carry this, Malord.
Thank you.
And the appointment orders will carry that, my lord.
Caveat.
Prescription.
Arguments could not be concluded today. Arguments could not be concluded today. Stuff. All these matters shall be heard on 11th of November. Stuff. Place all these cases in priority. Only one case. List this case on 11th of November in priority. In the meantime, if at all appointment letters are issued by the state, it would be made clear that it would be subject to the outcome of the writ petition.
Highly obliged, Lordship.
Plus the writ appeals.
Deeply obliged.
वो वाला मेरे पास देते ना अभी वो रिजर्व। Any other matter?